Hi, everyone. Welcome back to the Bravo docket. We're again diverging from what we planned to record to provide a quick episode on Tom and Ariana's response to Rachel's lawsuit. They've both responded.
Yes. So Ariana filed a declaration citing California's anti-SLAPP law, which if you've listened to our podcast, you know we've done multiple episodes on California's anti-SLAPP law.
Well, she actually filed the anti-SLAPP motion and then the declaration attached to that.
Yeah. And then Sandoval filed a motion to strike portions of Rachel's lawsuit that addressed the way the explicit video was obtained.
Well, he filed a demur.
Now,
a demur is the same as a motion to dismiss.
Okay, we don't use that term in any of the states where I practice.
I know. It's a special California term.
I think they use it in Virginia too, but none of the states that I'm licensed in use that term.
Yeah, I don't think he's seeking to strike anything, though. I think he's just seeking to dismiss the lawsuit. And then so is Ariana through her anti-SLAPP motion.
Is Sandoval's motion, would it be a complete dismissal of the lawsuit or just portions?
I mean, it depends on what he's... So I think he's seeking to dismiss every cause of action, so the entire lawsuit.
Sandoval's got a demur. Man, I cannot say that without a southern accent. A demur to the first cause of action for eavesdropping, and to the third cause of action for invasion of privacy, and to the fourth cause of action. Because
that wasn't against him.
Yeah, for intentional infliction of emotional distress.
Yeah, so he wants all the causes of action against him out because there wasn't a revenge porn cause of action against him. But Ariana
filed an anti-SLAPP motion to dismiss Raquel's entire lawsuit.
So similar. They're both seeking to knock out the claims against them and end the case.
Yes.
All right, let's start with Tom's, which again is the demur, which is a funny word for what is a motion to dismiss in California. Oh, so he's, fun fact, being represented by Rachel's attorney's brother.
Oh, yeah. We had someone send us that. That was crazy. I didn't realize that.
They're both the Garagos. They're going against them. Some brotherly competition.
Wait, so they're against each other?
Yeah, well, they're against each other in this.
Wow.
Yeah, Raquel's represented by one and Tom's represented by the other.
Interesting family dinners.
Yeah, I wonder if this is like beef that they've had for a while.
Yeah.
Matt Garagos, who is from Garagos Law Group, and then her attorney...
Rachel's?
Rachel's is from the firm Garagos and Garagos. So there's three of them?
I don't know.
So it's Mark Garagos is Rachel's lawyer, and Matt Garagos is Tom's lawyer. So it's Matt and Michael.
And I take it they're in different firms.
Yeah, but they both have Garagos in the name of their firm, which is why it's really confusing. One is Garagos and Garagos, and the other is Garagos Law Group.
That's really confusing.
That's so confusing.
You know, people are going to accidentally send emails to the wrong lawyer.
Yeah, that's tricky.
Mm-hmm.
Fun little fact. All right, should we get into this?
Starting with Sandoval's?
Yeah, let's start with Sandoval's.
They start with a summary of what happened. You're listening to this podcast, you have a good idea of what happened, I'm sure. And Sandoval, in the second paragraph of his introduction, states that Rachel's lawsuit is a thinly veiled attempt to extend her fame and to rebrand herself as the victim instead of the other woman, while denigrating her former friend, Ariana, as a, quote, scorned woman, and her former paramour, Sandoval, as, quote, predatory. And it says, indeed, to establish Rachel as the victim, her complaint contains irrelevant but incendiary allegations of Rachel's persecution by multiple non-parties, i.e., Bravo Media, Evolution Media, her former boyfriend, James Kennedy, Sheena Shea, and Andy Cohen.
Wonder if he listened to our podcast where we were like, why are these non-parties in there?
I know. So that's also going to sound familiar because we made some of the same comments. And that it says, notably, since November of 2023 to the present date, Rachel has actively maintained a provocative podcast, Rachel Goes Rogue, to further bend the narrative to her will. I mean, at this point, it's kind of just we're going to be adding commentary as we talk about this, but everyone that's involved in this, I really think, except for Ariana, is trying to bend the narrative to their will. I mean, Ariana's was, what I looked at was pretty factual information. I mean, they're still telling a narrative, but it's not like Sandoval's not trying to do the same thing with this response.
But also, even if Rachel's trying to get famous off of all this, it doesn't negate the fact that he may have recorded a video of her without her consent. So
exactly. That doesn't have anything to do with anything. But
no, just making her sound bad. It's always thinly veiled too.
I know.
That's like classic lawyer
Classic
language.
lawyer. The thing is we did make comments about that when we discussed Rachel's lawsuit, because this is really reading like a PR narrative as opposed to what's necessary for the elements of the claim in her lawsuit for a lot of it. But they could have also just focused on that as well. And we're here in the second paragraph of the introduction, and it's already another narrative.
Right. Like, let's stick to the elements, guys.
Yeah, there's a lot of commentary.
So they try and go into the history of the proceedings here, but again, there's some extra commentary where it says that the videos were actually created by Rachel and published by Rachel to Sandoval via a consensual exchange on FaceTime, i.e. their video calls. That is not how FaceTime works.
He's saying here, okay, so this is a direct quote. Sandoval is saying, quote, however, these videos were created by Rachel and published by Rachel to Sandoval via a consensual exchange on FaceTime, i.e. their video calls. So is he trying to say there that because she participated in the call that she created, that's not the same thing as giving someone permission to record it?
That's exactly what I was saying. And that's also not creating a video that you then publish to someone.
Right.
That is completely different. That wouldn't even... I know this isn't copyright, but it wouldn't even withstand a copyright claim. Like, Rachel doesn't have a copyright in her FaceTime video with Tom because she didn't create anything. He allegedly recorded her.
He says here, that was the way he characterizes it is, and again, this is direct quote from Sandoval's pleadings that he filed with the court. And it says, quote, based on Rachel's own allegations, Sandoval merely saved private copies of the videos that Rachel had filmed and shared with him. He's making it sound like she took a video and sent it to him.
Exactly. Yeah. And it's probably trying to confuse a judge who doesn't, I haven't looked up much on this judge to figure out if I think they know what FaceTime is, but they're probably hoping that a judge doesn't know.
But even people's grandparents know what FaceTime is. They FaceTime their grandchildren, you know? Like,
I know, but what they're doing is trying to muddle it up for a judge so that the judge thinks it was a recording that was sent instead of a real-time video that she didn't record and send to Tom. I mean, my grandma doesn't know what FaceTime is. So it really is a Hail Mary. Like, it's all that they can do.
I guess what else would we expect from Sandoval about this? I mean, he's not going to admit I recorded them without her permission. He's got to say something.
Right, exactly. They have to come up with something.
Or he could just tell the truth and say, I recorded them, but I never intended for them to be shared, and I thought Rachel was okay with it.
Maybe he says that later.
Yeah, we'll see. I'm already kind of mad.
Yeah. Okay, let's skip the authority. We don't need to tell you the law on demurs.
Even you say demur with kind of a southern accent.
Oh, no, right there I was saying it funny on purpose.
Oh, okay.
Demurs. No,
demurs. I cannot say that without an accent. Okay, yeah. This is very heavy on law. He says that Rachel's eavesdropping cause of action is based on her vague allegation in paragraph 48 of her complaint that, quote, unbeknownst to Rachel and without her consent, Sandoval surreptitiously recorded their communications. However, the complaint as a whole makes it clear that this cause of action is deficiently based on conduct rather than protected sound-based or symbol-based communications, as Rachel repeatedly refers to the complained of video recordings as sexually explicit or explicit without any reference to communications. All right, Ceci, what do you think he's saying there or trying to say there?
Yeah, so what they're trying to say is that this statute doesn't apply to that sort of communication. I think he's trying to say that it just applies to written communication and not to a video recording.
He's saying the eavesdropping cause of action makes it clear that the eavesdropping cause of action is deficiently based on conduct rather than protected sound-based or symbol-based communications. So, but I mean, you are eavesdropping according to the statute. It's not like she wasn't making any noise. I'm sure the eavesdropping statute says communication, so he's saying she's not trying the masturbation wasn't a communication, I think is what he's trying to say.
I think so too. I think a better argument, and maybe they make it later, would be that it wasn't eavesdropping because she consented to the call.
Which is making me think that there is video of him acknowledging that she didn't consent to the recording. I'm pulling up the eavesdropping statute in California. Okay, so that's just to go back to what the statute says. Unlawful eavesdropping or recording in California is a person who intentionally and without the consent of all parties to a confidential communication uses an electronic amplifying or recording device to eavesdrop upon or record the confidential communication. Yeah, they're trying real hard to get Sandoval out of this by using fancy lawyer words to be like, it wasn't a communication.
I don't think that was the right way to go with it.
No.
I think the right way to go would have been to say that she consented to the call.
You're right. But I think that they can't say that because they have Rachel's statement in her complaint, which I'm interested to see what they talk about this in here, that there's a recording of him admitting that she didn't agree to it. That's really interesting to talk about because obviously she did consent to a FaceTime call, but she did not consent to a recording of the FaceTime call.
So this is, again, I forgot that we talked about this already. So this statute is what codifies the two-party consent recording in California. So California is a two-party consent state. Both people have to agree to the recording in order for the recording to happen. Otherwise, it's illegal. So you're right. She didn't consent to the recording.
No.
She consented to the call.
And I think it's telling that so early on this, in page 5 even, Sandoval is trying to make an argument, sort of like a textualist argument, saying this doesn't technically violate the statute for eavesdropping because it's based on the masturbating conduct as opposed to, and this is directly what it says, sound-based or symbol-based communications. Well, first of all, I bet she was still making sounds. And
yeah, I bet she was saying...
Yeah. Yeah. And, I mean, this is a stretch.
It has to be.
Yeah.
That's when you have to get into the nitty-gritty of the words.
This is, again, a direct quote from this pleading filed by Sandoval's counsel. Rachel's most detailed description of the videos states in no uncertain terms that they do not contain communications, but are instead explicit videos that depict her in a state of undress and masturbating. Accordingly, this cause of action fails against Sandoval. For all the reasons Ceci and I just discussed, now I don't think that's going to work.
No.
Points for creativity, though. So for the listeners, they cite the California eavesdropping statute that we already talked about, which is a person who intentionally and without the consent of all parties to a confidential communication, blah, 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 uses an electronic recording device to eavesdrop on or record the confidential communication. In this case, it is the screen recording of the FaceTime call. And then they go on, and Sandoval's counsel brings up Section 632C of this same statute, which defines confidential communication. And it defines confidential communication as any communication carried on in circumstances as may reasonably indicate that any party to the communication desires it to be confined to the parties thereto. And then it says it excludes a communication made in a public gathering or a legislative, judicial, executive, or administrative proceeding open to the public, which we can cross that out right there. She was not masturbating in a city council meeting, or any other circumstance in which the parties to the communication may reasonably expect that the communication may be overheard or recorded. Well, she was in a hotel room, and he was ostensibly by himself as well. So here, Sandoval's attorney is arguing that the court must review the circumstances surrounding the communication. Well, she was in a hotel room masturbating over FaceTime.
But this is hard, too. Let me think about this. Wait, no, never mind. It's not hard. Never mind.
You're just, Ceci, you're a good attorney. So you're a good attorney. So you're like, all right, let me process and see if I can come up with, and you honestly, no doubt that you would come up with a really good argument. I would hire you as my counsel. But the court, any normal judge is going to say, counsel, are you really trying to tell me that when she was performing this act on FaceTime with her partner who's in a 10-year relationship with her best friend, that she wasn't expecting it to be private and to remain private? Mm-hmm. I mean, a spicy judge could have a field day with that, and I would love to watch that oral argument.
Totally. Well, what I was thinking was that because the statute reads like two people in a conversation and then a third party is, eavesdropping and overhearing that private conversation. But of course, the statute has been applied to this exact situation with FaceTime and
Yeah.
even within the same two-party communication, one party recording it is a violation of the statute. Just the way the statute reads. Because, of course, it's an older statute. It reads like two people, which I was going to point out in the prior section where he's saying that this isn't a communication. The case that they rely on most heavily is from 2000. Mm-hmm. Technology has changed significantly since 2000. And I know for a fact it has been applied to FaceTime recordings. But FaceTime recordings didn't exist back then. So he's using a really old case to try and make an argument.
And this attorney, which, by the way, we're not disparaging this attorney. They're doing their job, which is to defend Sandoval, and they're making the arguments that they can make. And some of them are very creative. It's just the facts don't really lend themselves to being helpful to Sandoval in this instance. They do bring up what Ceci and I brought up in our previous episodes on this. I'm talking about Sandoval's attorneys. It says, for example, at paragraph 21 of the complaint, Rachel alleges that, quote, although purportedly secret, the affair was, in fact, well known to many cast members and suspected by others. Rachel and Sandoval were not particularly discreet. Rachel is informed and believes, and on such information and belief alleges, that Ariana knew about it as early as fall of 2022. So they're trying to make an argument that because Rachel said in her complaint that a lot of people knew about the affair and that it was not particularly discreet, that then this evidence of the affair, which includes her masturbating in a state of undress, is somehow not a confidential communication.
She's not complaining that he outed the affair. She's complaining that he recorded her. It's two different things.
Well, I think she does make the intentional infliction of emotional distress claim. And so I think they're kind of conflating things here. But
yeah, at least for this cause of action.
Yeah. Again, at oral argument, a judge would have a field day with this.
Right. So you're telling me, counsel.
Exactly.
Because everyone knew of this affair, it was okay for your client to allegedly record Miss Levis. I don't even know who the judge is. Why am I talking like that?
Because anybody that's practiced law long enough has been in front of a judge where you've had to make an argument to defend your client and you knew it was going to be a difficult argument to make, but you make it in good faith. And then the judge comes back with this really common sense question and you're like, oh, crap.
And you're like, yes.
Your Honor, that's an excellent point. However, and you try to redirect. And
but did you see that comma in the statute? I think that,
yeah,
I think that changes the meaning of. All right. So the next argument is that they're arguing Rachel's third cause of action for invasion of privacy fails because plaintiff Rachel does not allege any facts showing an intrusion by defendant Sandoval.
So it says Rachel's third cause of action is based on her allegation that Sandoval invaded Rachel's privacy by, among other things, secretly recording their private communications and capturing sexually explicit footage of Rachel without her knowledge or consent in a manner highly offensive to a reasonable person. And then they go on and talk about the right to privacy.
So in an intrusion case, this is what they're arguing. Courts first ask whether a defendant has intentionally intruded physically or otherwise on the plaintiff's solitude or seclusion, that is, into a place or conversation private to the plaintiff. To prove actionable intrusion, the plaintiff must show that defendant penetrated some zone of physical or sensory privacy surrounding or obtained unwanted access to data about the plaintiff.
Sandoval's counsel is trying to argue here that Rachel intended for Sandoval to see the explicit videos and that, again, Ceci made an excellent point. They're trying to equate FaceTime with a video, but just because it occurs through a video transmission is not the same thing as creating a video and sending it to someone, which they will then have in their possession. Ceci's right. This is what they're trying to argue. So they're saying Rachel intended Sandoval to see her explicit videos, which means that he intended, but they're carefully not wording it like Rachel intended Sandoval to see her on FaceTime. And Rachel made the videos for Sandoval, so Rachel appeared on FaceTime for Sandoval, and that Rachel shared the videos with Sandoval via a consensual exchange on FaceTime, i.e. their video calls. Ceci, I think you're absolutely right. I think they're really trying to confuse this for the court. Mm-hmm. And yeah, it's not the same thing. And that's really all there is to this argument for intrusion of privacy. There's not much there.
Yeah, so here's a case that maybe Rachel's counsel will use in their opposition. But it says the tort of intrusion encompasses unconsented to physical intrusion into the home, hospital room, or other place the privacy of which is legally recognized, as well as unwarranted sensory intrusions such as eavesdropping, wiretapping, and visual or photographic spying.
I mean, yeah, visual or like wiretapping is listening in and recording something that you weren't expecting it to be recorded.
Mm-hmm.
Yeah.
But this isn't wiretapping. This is the...
Right. Intrusion of privacy.
But she thought that would remain between them.
Next, Sandoval's alleging that her fourth cause of action, meaning Rachel's fourth cause of action for intentional infliction of emotional distress, fails against Sandoval because Rachel does not allege any facts showing that Sandoval's conduct was outrageous, done with the requisite intent, or that her injuries were actually and proximately caused by Sandoval's conduct.
So the three elements are extreme and outrageous conduct by the defendant with the intention of causing a reckless disregard of the probability of causing emotional distress. The second one is the plaintiff suffered severe or extreme emotional distress. And the third is that the plaintiff's injuries were actually and proximately caused by the defendant's outrageous conduct.
Now, if you listen to our previous episodes, this is the one where I think the last part of that may have some teeth, because we talked about how she brings up all of these other reasons in her complaint about why she's upset, and includes actions from Bravo, actions from Lisa Vanderpump, actions from Evolution Media, actions from Sheena Shea. And we talked about, Ceci and I talked about extensively how that actually harms Rachel's claims in this case, because it's basically giving them on a silver platter all these other reasons for causation of her emotional distress.
I mean, I know they're going to argue this, and I probably would argue it too. I think element one is going to be difficult for Rachel to prove, because I think from what I remember from studying for the bar, it says outrageous. And the examples that I remember from the bar were like someone killing someone's child right in front of them.
Right. We talked about this in the last episode. Like, one of the examples was for outrageous conduct was a news reporter talking to children and telling them that their friends who were also children had been murdered without their parents around, and interviewing them on TV and causing emotional distress.
Right. So the argument that they make is what I was just saying, that to meet the first element of it being outrageous, the case law says that it has to be so extreme as to exceed all bounds of that usually tolerated in a civilized community. And, you know, I mean, someone could be like, well, in a civilized community, we don't record private videos, but it happens more often than not. So I just don't think this is the cause of action for the conduct alleged here. I mean, they're making the wrong argument now that I'm reading it more.
Yeah, they're making the wrong argument. Sandoval's counsel does argue that to establish the first element for intentional infliction of emotional distress, that the conduct must be intended to inflict injury or engaged in with the realization that the injury will result. But I think that there's a common sense argument that if you are having an affair with your best friend's boyfriend of 10 years and he's recording you without your consent, that if those videos got out, that an injury would result, meaning that it would be extremely upsetting to Rachel.
True, but the tough thing for Rachel is that the allegation is that Tom's only part was doing the recording and then saving it on his phone, not the distribution.
We do think this is her most difficult claim, but this is one where I feel like if I had to be Sandoval's attorney, I could argue against this one with a straight face, maybe.
Right. But yeah, what I'm trying to say is that combined, yes, all the actions combined, I could see being outrageous and emotionally distressing, but taken piece by piece, which I think is the correct thing to do here, is Sandoval recording Rachel, which is all that's alleged against Tom. There's no distribution argument against Tom because it was just on his phone. You know, there's no revenge porn cause of action against him. That alone was that outrageous conduct. I don't think so. I mean, yes, in the common sense form of it, I feel like everyone listening is going to be like, yeah, of course that's outrageous. But from a legal perspective, it's not the same.
Yeah.
As being like, that's outrageous. That's not what they...
It is really
not the
difficult.
Same as illegal.
When you look at the case law in almost any state for what is defined as outrageous, and then the examples where the court has upheld what outrageous behavior is, it is really difficult. It's a very high standard.
And I'm pretty sure that outrageous in California is going to be a little bit higher than outrageous in the South or some other state.
Yeah, that also makes sense.
There's a lot of outrageous in California, I think.
I mean, Kansas is one of the states that I'm licensed in. And I mean, that's right in the middle of the country. And even the standard in Kansas for outrageous conduct is pretty high. Sandoval's attorney says that, quote, as Rachel does not allege Sandoval disseminated the videos, she can show no actual and proximate causation. And additionally, any emotional distress Rachel alleges to have suffered was also caused in a large part by her decision to star in a salacious and drama-filled reality television series and to engage in an affair with her friend's longtime boyfriend. Ugh. And then he says she admits to this in her complaint, which is...
That is the wrong argument, guys.
I know.
Come on. They just can't help it, though. They're like, we have to make a dig at her.
Yeah, they can't help it.
Dumb. Sorry. I'll cut that out.
No, I don't think you should.
But they started this argument really well, pointing out the high bar for outrageous conduct and then just kind of crashed it by the end.
Yeah. This is also obnoxious. Their last heading in this says, at a minimum, Rachel's complaint is uncertain with respect to all causes of action asserted against defendant Sandoval. And it says that the allegations which purport to state liability for eavesdropping, invasion of privacy, and intentional infliction of emotional distress are uncertain because the line of demarcation between private conduct and the plot of an ongoing television reality series is wholly unclear based on the complaint.
Like a Hail Mary.
Yeah. Sandoval's attorney is correctly pointing out that some of the things in Rachel's complaint, which Ceci and I pointed out, weaken her claims here, because how do you separate out the damages for which thing? And her own actions of being revealed to have slept with her best friend's partner of 10 years and the backlash against that as opposed to the video getting out. But Rachel's attorney very wisely tied everything that happened to her, basically saying like, everything that happened was a result of the first domino falling, which is the fact that Sandoval recorded these videos without her consent and saved them on his phone without her consent. And then Ariana found them. I feel like, just doing commentary here, Rachel's attorney did a really good job of tying it back to that.
I have 2 points. First, so I've never seen someone make an argument under this. It's that the pleading is uncertain. As used in the subdivision, uncertain includes ambiguous and unintelligible. They're basically saying that the complaint's unintelligible. Definitely a Hail Mary.
Yeah.
Second point.
Yeah. No, I'm agreeing with you. Yeah.
Second point I want to make is that this is going to be a really interesting case for a damages expert to come into if they get to that point, which the damages expert is usually used in most cases. And they're the ones that look at all the evidence and try and calculate damages and blah, blah, blah. But this one's going to be interesting because I bet Rachel's going to want to, like she does in her complaint, say that everything was caused by this one thing, like you were just saying, the domino effect. And then Tom's expert for damages, if they get one, is going to want to parse it out and be like, how much of this is attributable to her having an affair and being on TV and all that, and how much of it is attributable to him recording this.
I mean, very interesting. And this is just me speculating, but we've been watching on the current season of Vanderpump Rules how Tom is ostensibly very upset that Rachel has cut off contact with him, but she was in the treatment facility during this time. You kind of wonder, was she having a realization that, one, Tom isn't the person who she thought he was, and the fact that probably a lot of his actions were harmful to her. But when you're talking to a therapist and you have your therapist trying to get you to realize what someone has done is actually really wrong, and the full degree of that, and the fact that they are on a reality television show and he is recording her at her most private moment that she thought was an intimate private moment between them. He's recording that and saving that on his phone, knowing that they are on a show. What if his phone gets hacked or something else? Like the lack of care for her well-being in general, that had to be sort of astounding to her, I think.
Mm-hmm. Yeah.
I mean, despite not just the legal causes of action, but just this person that said all these things to you, that told you his relationship with Ariana was over, whatever, is then recording secret videos of you in your most vulnerable state when you think it's just an intimate moment between you. and him and then saving them on his phone. And for what? For what?
And it's so unnecessary.
Yeah.
If they were,
for what? Like, why?
if they were engaged in sexual relations, like, why?
Why? What? I mean, man, I would love to take Sandoval's deposition.
Just got like a vision of it.
Oh my God.
White nail polish.
I can tell you, Sandoval would be the type of witness who thinks that he can outsmart the attorney and he would not be able to shut up. He would be the type that if you started asking him questions, you could lull him into complacency. And then he just thinks he's talking to someone who's just really interested in everything he has to say. And then he would just keep talking.
I bet he wouldn't even wear a suit.
No, he'd
He
probably
would sit really far back in his chair.
totally.
Totally. All right. Moving on to Ariana's declaration in support of her anti-SLAPP. Let's just read it.
Yep.
All right. 1. I am the defendant in this action. I make this declaration in support of the special motion to strike pursuant to Code of Civil Procedure Section 425.16 filed concurrently herewith. I have personal knowledge of the matters stated herein, except where stated on information and belief, and if called as a witness, I would and could competently testify thereto. That's just pretty standard.
Yes. But, and this is another brief commentary, when you are someone's attorney and you're having them do this declaration, you're very careful to make sure that it's as accurate as possible and there isn't anything that is going to harm your client or be used against your client in the future. So I'm assuming Ariana has good attorneys and that's what was done here. So as of March 1st, 2023, I had been in a committed relationship with defendant Tom Sandoval for over 9 years.
During the evening of March 1st, 2023, I went to a club in West Hollywood, Tom Tom, to see Mr. Sandoval's band play. Side note, I've been there twice.
I've never been to Tom Tom.
The past 3 months.
I need to move to LA.
I went a couple, or last month with Steven from Faces by Bravo.
Fun.
Yeah, it was really nice.
While playing, I think because she calls him Mr. Sandoval. She could have just said Sandoval.
Oh, I like putting Mr. and Miss.
For me, it depends on the context. While playing, Mr. Sandoval's phone fell from his pocket and a mutual friend handed it to me.
Because we had been in a committed relationship for so long and because we trusted one another and presumably did not keep secrets from one another, I knew many of Mr. Sandoval's passcodes, including the one for his phone. I had previously accessed Mr. Sandoval's phone on other occasions with his knowledge and consent.
Side note, that's important because if he gave Ariana the passcode to his phone, Ariana has a very strong argument that Sandoval didn't have an expectation of privacy with Ariana looking at his phone. There's been other cases I've looked at, not in California, but where husband and wife are in a divorce and the wife gave the husband all the passcodes to their phone or the other way around. And the court found that while typically there would be, even between a husband and wife, an expectation of privacy, if you share all of your passcodes with them, then you've essentially given them the key to everything and you can't make the same claims. Which also
Forever?
makes...
That's kind of crazy.
Not forever, but within the framework of circumstances. I'm not saying this applies in California, but I have seen those cases where the court has found you shared all of your passcodes. It was a community computer or whatever. And then even to your own email accounts, you had given permission on multiple occasions for this person to go in and check your email or do whatever, and you didn't revoke it. And so now you can't claim that they violated your privacy or did something else. But also that makes it so much worse that Sandoval is taking these recordings and just leaving them on his phone and not even changing the passcode to his phone.
Well, he said he usually deletes that kind of stuff. Yeah, I guess change your password if you're doing something bad. It's so stupid.
For reasons I still do not know, call it a woman's intuition, when the set ended, I felt the need to check Mr. Sandoval's phone and went to the women's room for privacy.
In a locked stall, I accessed Mr. Sandoval's phone and saw text conversations between Mr. Sandoval and plaintiff that appeared to be incomplete because portions of them had been deleted, which made me suspicious.
Yeah, that's the other thing. Oh, you're going to delete some text messages, but you're going to leave the videos on there. While other women waited to use the toilet, I opened the photo app on Mr. Sandoval's phone and was shocked to find a video of a FaceTime call between Mr. Sandoval and Rachel that showed Mr. Sandoval's face in the upper corner while the main image was of Rachel masturbating. I hurriedly took out my own phone and made 2 recordings of the FaceTime video. Prior to that moment, I considered Rachel a friend and did not know that she and Mr. Sandoval were having an affair. Okay, so I like what she's doing here. She is just being completely honest. She's,
Right.
I have found out that someone has cheated on me, and you are shaking and you suddenly realize that everything that you thought was one way is actually another. And then all of a sudden, all the thoughts come in your head of like all those little exchanges and then all the times you've been together. And then you're like, how long was it going on? It's a horrible feeling. And she's being very honest here. She said, yeah, I did take a recording of what was on his phone. Like, I'm assuming she did it with her phone.
No, that's what she says.
Yeah.
But that's something I didn't know, because we thought that Rachel alleged that Ariana sent it to herself. But Ariana's saying that she took her own video on her phone of the video.
Which he just took a video of another video, which I think is different than sending it.
You mean distributing?
Distributing, yeah. That could be an argument that her attorney could make with a straight face.
Agreed, but it doesn't really help the other ones.
No.
Invasion of privacy.
But you can make that argument with a straight face.
Totally. I also just like that she included while other women waited to use the toilet.
Eric's so considerate. She's like, I'm feeling bad that other women are waiting to use the bathroom. Yeah. Which, by the way,
she's like, can we add that there were other women?
It's like, not only did Sandoval cheat on me and do all these terrible things, other women had to wait longer for the bathroom. Which, by the way, there needs to be an ordinance passed in every state, every city, every county that you have to have the appropriate number of stalls for the bathroom for the amount of people that are there. And like, it's so frustrating.
They had a big bathroom, but okay. I left the bathroom and walked up to Mr. Sandoval, who asked if I wanted to go into the alley for a cigarette.
In the alley, I confronted Mr. Sandoval about his affair with Rachel.
Concerned that people might overhear us, Mr. Sandoval tried to move me away from the club.
Around the same time, I sent the videos I recorded to Rachel along with a text message reading, "You're dead to me." A true and correct copy of a screenshot of that message is attached here too as Exhibit 1.
I did not send the videos to anyone else, nor did I share, display, or show the videos to anyone else. To be clear, I only saw the video of plaintiff masturbating in places secluded from others, i.e., alone in the bathroom stall and in the alley with Mr. Sandoval.
A heated argument ensued between me and Mr. Sandoval, and Mr. Sandoval forcibly grabbed my phone from my hands, causing my credit cards and driver's license to fall to the pavement.
I quickly grabbed my cards off the pavement and chased after Mr. Sandoval, who would further distance himself from the club.
By the time I caught up to him, Mr. Sandoval had deleted from my phone the videos I had recorded of the FaceTime video.
Mr. Sandoval also deleted the videos from the recently deleted folder on my phone.
Minutes later, I texted one of my friends about what happened, stating, I called Rachel after finding out and texting her the videos of herself from Tom's phone that I took. Tom took my phone and deleted them, chased him all the way down San Vicente. True and correct copies of the screenshots I took of those messages are attached here too as Exhibit 2.
After learning about the affair, I began informing my family and other close friends about plaintiff's affair with Mr. Sandoval, including how I learned about it by discovering the texts and the FaceTime video on Mr. Sandoval's phone.
I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. Executed April 26, 2024, Los Angeles, California. And then Ariana signs it. All right. Oh, this is sad.
Mm-hmm.
Okay, I'll be Rachel, you be Ariana. We're just going to read the text messages to you, and we're going to start before it goes. Yeah.
So we're going to watch the Watch What Happens Live episode now.
Oh, nice. I'm trying to find the whole episode on YouTube right now, but I don't think it's out yet.
Same. It's not on Peacock. If you have Spectrum, it will be on at 3.
And there's like, the
laughing, crying emoji.
Yeah. 40 more minutes. Yay. I'm happy you're coming with Brad and Jamie. So that was Saturday, February 25th at 10:01 p.m.
And then Wednesday at 9:37 p.m., Ariana texts her and says, "You are dead to me."
And dead to me is in all caps. That was Wednesday that Ariana texted, "You are dead to me." Friday, Rachel says, "Ariana, I don't know what to say right now besides I really fucked up and I am so, so sorry."
And then Ariana responds, "Shut the fuck up, you fucking rat." And then she stops sharing her location with Rachel. I mean, in her declaration, she says that she sent the video that she had taken to Rachel, but I don't see it. Any indication that it was, maybe she deleted the message.
I'm guessing either she deleted the message or Tom, when he took her phone, because she said Tom ran off and took her phone.
He deleted it from her photo app.
her photo app, and then he deleted it from recently deleted. But it also makes me, I can see Tom looking at her phone and being like, oh shit, what did she send Rachel? But she probably deleted them herself later on.
Yeah, I think she probably deleted it once she got the cease and desist.
Yeah, that would be my guess.
All right. Then she texts her
friend.
Her friend. And part of it is redacted.
But the relevant part is just basically her proving we're just talking about. I called her after finding out and texting her the videos of herself from Tom's phone that I took. Tom took my phone and deleted them, chased him all the way down San Vicente, which is what she said. So, I mean, I think Ariana is doing the right thing here and just being honest and providing the receipts. So, and it's already, it's 9:30 p.m. in Texas right now, and we are going to stop here. We haven't gotten to Ariana's SLAPP motion yet. And again, I'm sorry, we don't mean to keep pushing off these fascinating topics and research for the Marco lawsuit against Erica, but you guys asked, so we changed our plan last minute.
And I think by the time we get back, more will have happened.
Yeah.
So it'll be a more robust episode.
Yeah.
So do you think we'll do another part where we go through her SLAPP motion?
I don't want to make any promises.
I think we should, because in that she's going to argue why Rachel's claim should fail.
Yeah, there's no way we can't. I'm honestly so interested in this in general. I'm glad you guys asked us to go ahead and do this, because this was really fun to go through and talk about with Ceci.
Yeah. All right. Well, we will chat with you guys another time.
Bye, legal team.